Welcome to the Supreme Court of the United Kingdom, where today we're beginning the hearing of the appeal of SC, CB and 8 children and the Secretary of State for Work and Pensions. Details of the case can be found on our website by following the links to cases and then current cases. But in brief, the Supreme Court is being asked in this appeal to decide whether the two-child limit, a provision in an Act of Parliament which restricts the payment of amounts of child tax credit to the first 2 children in a family, is incompatible with the rights of the appellants, who are 2 parents and their children, under the European Convention on Human Rights. I'm hearing this appeal with 6 of my colleagues, and I should begin by introducing the panel. I'm sitting with Deputy President Lord Hodge.
Good afternoon.
Lady Black.
Good afternoon.
Lord Lloyd-Jones. Lord Kitchen.
Good afternoon.
Lord Sales.
Good afternoon.
And Lord Stevens. Because there are children who are party to this case, the court has made an order that no one shall publish or reveal the names or addresses of the appellants who are the subject of these proceedings, or publish or reveal any information which would be likely to lead to the identification of the appellants or of any members of their family in connection with these proceedings. The appellants are represented by a number of counsel, led by Mr. Richard Drabble, Queen's Counsel. And so I'll turn now to Mr. Drabble and invite him to begin his submissions. Mr. Drabble. You're muted, Mr. Drabble.
Hope I'm now unmuted.
Yes.
As your Lordship has said, for instance, on most of Parliament, the various my love friends the Queen Award fund and appear for the Secretary of State, and had about 3 Queen to actually side for dinner. And all I've seen appeal by which in turn they from justice.
Mr. Drabble, I'm sorry to interrupt you. I'm able to make out what you're saying, but there is a good deal of crackle. I'm not sure if I'm the only person who's having that problem. No, I'm not. I wonder if it might be worth, before you embark on the substance of your submissions, it might be worth just taking a moment or two. I'm getting a message from our IT engineer saying that they need you to reconnect, Mr. Drabble. Shall we perhaps adjourn the hearing just for, I think, a couple of minutes while you do that? I suggest we simply mute ourselves and stop our video feed, and our IT engineer can get in touch with you, Mr. Drabble, to sort this out. Okay?
Yep.
Welcome to the Supreme Court. We hope we've now resolved the technical problem that was troubling us. So I'll return now to Mr. Drabble and invite him to continue his submissions.
Yes. Well, I've just given the court a rather daunting shopping list of the issues which my case requires me to address, some of them fairly shortly. But the first of them was the statutory scheme, which, if I could ask the court to look at the statement of facts and issues as the way into the exposition of that. It's EF 74. And the footnote on EF 74 gives the references to the sections 13 and 14 of the Welfare Reform Act 2016, which amend the Tax Credits Act 2002 concerning child tax credit, and the Welfare Reform Act 2012 regarding universal credit. And your lordships and my lady will find the Tax Credit Act 2002 at EF 1062, which is in volume 1 of the authorities bundle.
Well, I should tell you, Mr. Drabble, we're working only from electronic. We only have an electronic bundle. We do have hard copies of a small number of key documents comprising the judgments and orders below the parties' cases and the SFI, but for everything else, we're looking at an electronic bundle.
Yes, I assume if I give the court, therefore, the EF number, the electronic file numbers, that will do.
Yes,
being me, I'm working off hard copies in parallel, but I'm fairly well used to that.
You may not be alone.
But I hope we might remember to write down the electronic file numbers to each of the references. So I'll try and stay with that as we go along, and see if that works. So if the court has EF 1062, therefore, you should be in section 1, subsection 1 of the Tax Credits Act 2002. This is in its amended form. So this incorporates the amendments that I've just shown the court the reference to in the footnote to the SFI. Section 1.1 indicates that the Act makes provision for a tax credit to be known as child tax credit, and B, a tax credit to be known as working tax credit. And if we go on through the statute, get to EF 1063, next page, we have the basic entitlement in section 8, subsection 1. The entitlement of the person or persons by whom a claim for child tax credit has been made is dependent on him, or either of both of them, being responsible for one or more children or qualifying young persons, and then the regulation making power to deal with the circumstances in which you're treated as being responsible for the child. And then at section 9, EF 1064, we get nearer to the heart of the case. Section 9 is head of maximum rate. Section 9.1, the maximum rate at which a person or persons may be entitled to child tax credit is to be determined in the prescribed manner. Then the prescribed manner of determination must include the inclusion of an element which is to be included in the case of every person or persons entitled to child tax credit, who is or both of whom are responsible for a child or qualifying young person who is born before the 6th of April 2017, an element in respect of each child or qualifying person whom this person is or both of them is responsible. And then I think there's a severe disablement premium, which we're not closely concerned in this case, provided for in section 9.2c. And then 9.3 provides that the element specified in paragraph A of subsection 2 is to be known as the family element of child tax credit, and that specified in paragraph B of that section is to be known as the individual element of child tax credit, and then C is a disability element of child tax credit. So you have a family element, the structure of child tax credit, you have a family element unaffected by these reforms and these issues, and you have an individual element of child tax credit in respect of the child. When we get into 3A, 3 large A, we are dealing with the provisions that bite in this case. 3A provides subsection 3 large b applies in the case of a person or persons entitled to child tax credit where the person is, or either or both of them is or are, responsible for a child or qualifying young person born on or after the 6th of April 2017. Prescribed, and then B, large B, the prescribed manner of determination in relation to person or persons must not include an individual element of child tax credit in respect of the child or qualifying young person unless he is or they are claiming the individual element of child tax credit for no more than one other child or qualifying young person, or B, the prescribed exception applies. So that's the basic provision, which we say produces an incompatible result on the facts of our cases. It's the requirement, the mandatory requirement, that the prescribed manner of determination must not include an individual child tax credit in respect of the child or qualifying young person, unless there's no more than one other child or qualifying young person in what one might loosely call the assessment unit for these purposes, or B, and the prescribed exception applies. And then 4 and 5 are other provisions that are less directly in play but are relevant to the calculation of child tax credit. That, I think, is all I need to do in terms of the basic statutory provisions. If the court needs to see the amended versions, well, the court may at some point, because it deals with universal credit, but I don't think there's any need to deal with it in detail now. The court will find the amended version of the Welfare Reform Act 2012, sections at 1, 8 and 10, at EF 1534 to 1536. In my language, that's volume 2 of the Authorities Bundles, tab 16, but in EF terms, it's 1534 to 1536. And the Welfare Reform and Work Act, which makes the amendments, is at 1537. So I can then pick up some other features of the statutory scheme. If the court will go to EF 75, we're back in the Statement of Facts and Issues. And the Statement of Facts and Issues at paragraphs 6 to 11 describes the benefits affected by the 2-child limit. So paragraph 6 says that child tax credit is paid to people who are responsible for children, claimed by people who are in work and also by those who are not, calculated on an annual basis, and then the amounts are given. And paragraph 7 of the SFI, EF 76, describes a similar position in relation to universal credit. And then paragraphs 8, 9, and 10 describe other benefits which are available to families with children. Particular note, child benefit and housing benefit, child benefit being dealt with in paragraph 8 of the SFI, and paragraph 10 of the SFI dealing with housing benefit. And then paragraph 11 lists a number, or draws attention to a paragraph of the Respondents' witness statement, Mr. Higlett's witness statement, which sets out other support available to families with children, set out in paragraph 72 of the witness statement of David Higlett. And then the SFI EF 77 gives a short description. Your Lordship will find similar short passage in the judgment of Lord Justice Leggett in the Court of Appeal. Paragraph 14 records the fact that both SC and CB were entitled to full FCTC without any reduction on the ground of income at the time of their claim. So if I can then just interpose into that description of the statutory material, a passage in the judgment of Lord Justice Leggett, which enables one to potentially get a handle on the scale of the potential effect once the scheme has come to full fruition. Obviously, at the moment, we're largely dealing with third subsequent children born to families after 2017. But as the scheme went its way all the way through, you will get families that are entirely subject to the scheme, entirely composed of children born after the start date of April 2017. Lord Justice Leggett, in the judgment at EF 243, is actually dealing with a matter we'll need to come back to, because he's dealing with the position on the government's assessment of the best interests of the children during the, as required by Article 3, in our case, as required by Article 3 of the UNCRC. But he says, so far as the evidence shows, no claim was made on behalf of the government during the passage that limited to 2 the number of individual elements of child tax credit payable to a family with more than 2 children is in the best interest of the children themselves. Such a counterintuitive claim would have required evidence, and analysis was reported and was vouchsafed. But that is all for later. The reason for saying that is the size of the financial impact. If the court will pick that paragraph up, about 8 or 9 lines down, Lord Justice Leggett is inviting the reader to take the example given by the Chancellor of the Exchequer, an out-of-work family of 5 children to whom the 2-child limit applies, instead of receiving over 14,000 a year to meet the children's subsistence needs, as was the case in 2015, will at current rates receive only £5,560 a year, which is the maximum individual element of child tax credit for 2 children and amounts to only £1,120 a year for each child, if it has to be spread across the 5 children. This works out at around £21.50 per child per week, substantially less, albeit without taking account of child benefit, than the allowance of £39.95 per child per week, which, according to a Home Office report, is the sum necessary to meet the essential needs of asylum seekers. And then he gives the reader the reference for that material. And then he makes the point that I made a moment ago. Full impact has not been felt by families such as the claimants in these proceedings, because the 2-child limit only applies to children born after the 6th of April 2017. But in the long term, for an out-of-work family of 5 children, at least 3 of whom are born after 2017, the 2-child limit will have this financial effect.
Can I just ask for a little clarification of what's said there? The 5560 figure is the individual element, is really the maximum individual element of child tax credit. Is that right?
Yes, what Lord Justice Leggett has done is total the maximum individual element of child tax credit for 2 children
Yes.
Yes, so that, yes, your lordship is right. The 5560 is the maximum amount for 2 children, then spread it over 5 children,
Yes.
and the maths follows from that. That's what's happening.
And when he says that that's to meet the children's subsistence needs, I'm not quite sure what exactly he means by that, but we know that it's not the only benefit that would be received by a family in poverty.
No, that's entirely right. But we may need to do this in detail. But we deal with it in our case. The child tax credit is the only benefit that's available to meet day-to-day needs like food, clothing, and matters of that sort. There are other benefits available, and I showed your lordship a moment ago. The list in the statement of facts and issues.
Yes.
The notable ones are housing benefit, which obviously deals with housing costs and not food, if I could put it crudely.
Yes. Yes.
And child benefit.
Yes, and what's child benefit for?
Well, child benefit is available, but it's a universal benefit. I would say crudely, a universal benefit. It's now taxed if people are receiving income at a higher level. If you're over 50,000, then you are taxed on your child benefit. But subject to that, it's a benefit that everyone gets. So it's a universal benefit.
Yeah.
Paid in respective children. The specific subsistence benefit, which is the point that Leggett is making, is contained within the child tax regime.
Yeah. So, and if you're doing a comparison with the asylum seeker, I'm just trying to understand this. The family, the non-asylum seeker family, they would receive the family element of child tax credit, the individual element for 2 children, which is 5560 figure, child benefit and any other benefits to which they were entitled, such as free school meals and so forth, housing benefit, and if one tries to compare that with the figure given for asylum seekers, what's the comparison?
Well, the comparison, I mean, that's the cash, as I understand it, the cash sum of £36.95 per child per week is the equivalent of the individual child element of child tax credit. It's a sum available for the specific.
So would the asylum-seeking family also receive the family element or an equivalent of the family element of child tax credit, child benefit, free school meals, free childcare, and so forth, housing benefit?
I was looking.
I'm just wondering if we're comparing like with like. That's really what it boils down to.
I'll come back to the detail of that, although it's not a crucial element of the argument. I mean, the Secretary of State has never said Lord Justice Leggett's approach in 153. I'm more interested, for present purposes, simply on the scale of the impact. If
you're comparing the effect of the saving of public expenditure down from 14,000 in 2015 to this element of the benefits to 5560 in whenever it was that it came into force, 2017.
Leaving a payment to each individual child, if you're dealing with a 5-child family, of £21.50 per week. So it's a pretty stark issue as the adequacy of that sum. And I'll be making some very short submissions, but submissions.
Well, it depends again on whether its significance depends on how large a proportion of the total family income it is.
Yes, but if we're assuming that we're looking at child tax credit playing its role as the subsistence benefit, as your lordship has seen and in any event understand, that it's payable to people in work and is subject to a taper. So you can be earning really quite a lot of money and still on child tax credit. It's an issue that's arisen in the benefit cap legislation. But ignoring that and looking at it on the assumption that you have no other income, so you're dealing with the maximum amounts, then the working assumption is that the amount of the family element meets the expenses of the food, etc., expenses of the couple, if I can very crudely put it like that. Then you have an individual element payable in respect to the child. On the example in Lord Justice Legate's paragraph 153, the family element is untouched, so the amount payable for the living expenses of the adult is untouched, but the amount available notionally, as it were, for the living expenses of the children is reduced down to £36. Sorry, I'm looking at the wrong figure. Is reduced down to £21.50.
Why do you treat the family element as being hypothecated to the subsistence needs of the parents? It's payable to families with children.
It's not a question of hypothecation. It's a question of the assumption of what elements are available for what needs. So a family or with one child will get the same family element because it is what it says. It's the basic element for the living expenses of the couple, or assuming that you're dealing with two claimants or a family element of two. And then you get. So, I mean, obviously, in the real world, the vice of the policy from our point of view is that the family with 3 or more children will be forced to use the family element, which is, on the face of it, adequate for the couple across the range of the children's needs.
But a couple wouldn't qualify for the family element. They have to be responsible for their children. Well, you might want to, I don't know, to come back to this in some form at some stage.
Yeah, but I mean, the point remains that the element that Lord Justice Legate is talking about in paragraph 153 is talking, as we've seen in the primary legislation, is talking about the individual child element, plainly there in respect of the presence in the household of the children. And the point is relatively simple. The point is that if you've got 2 children, you're getting the amount of 5,560 a year, which is presumably to meet the needs of those 2 children. You then spread it across 5. I mean, the point at the end of the day is no more sophisticated than that, but it is a substantial impact, very substantial impact. And one of the issues is what, if anything, has been done in order to assess the appropriateness of these figures. So, and my Lord, if your Lordship's content with that for the moment, I mean,
well, I think you've answered it as well as you probably can.
Well, I mean, it's obviously important to actually understand, and for me to understand and explain the way in which the figures work. But I only went, possibly unwisely, but I went to paragraph 153 just so that you see we're not dealing with trivial amounts or small impacts on living standards. We're dealing with very substantial impacts indeed, at least when the policy is rolled out fully over time. That's the point. the next step, as it were, is to ask the court to look at what material is available in terms of the explanation for the policy, the rationale for the policy. There will be two markers that I put down to explore later in the submissions. First of all, what discussion is there of the adequacy of the figures that are involved? And secondly, a matter which we'll have to look at in a bit more detail, what discussion is there of the best interests of children pursuant to the duty on the UK created by Article 3. So if the court will pick up the judgment, and I'm asking the court to look at paragraphs 16 and 17 of the judgment at EF 206 and 207. Paragraph 16 sets out a quotation from the Chancellor of the Exchequer. You will find this in the papers in Mr. Higlett's witness statement at EF 568. I'm going to ask the court. The court wants to look at the witness statement itself. It simply quotes the passage, so it's not a quotation from a larger document. It's simply a passage. And this is the example that Lord Justice Leggett was picking up in the paragraph 153 that we've just been looking at. So in the quotation, what it says is, the budget will also reform tax credits to make them fairer and more affordable. On top of child benefit for every child, an out-of-work family of 5 children can currently claim over £14,000 a year in tax credits alone. And then, critical phrase, the government believes that those in receipt of tax credits should face the same financial choices about having children as those supporting themselves solely through work. Budget will therefore limit support to families through tax credits to 2 children, so that any subsequent children born after April 2017 will not be eligible for further support. So that concept, that an important element in the rationale for the policy, is that those on benefit, claiming tax credits, should face the same financial choices about having children as supporting themselves solely through work, recurs throughout the policy documents. That makes it sound as if there's an awful lot of them. There aren't, but it is the recurring piece of the rationale. And there's a passage in Lord Justice Leggett's judgment towards the end of the judgment, dealing with the justification of the impact on families with 3 or more children, where he discusses whether or not that concept of facing the same financial choices is a legitimate way of looking at it. We have criticisms of it in the printed case, which we'll come to and develop more fully as we go along. Paragraph 17 is referring to material which the court will find at EF 675, 676 and 677. It's an impact assessment dated July 2015. And as I say, if I could ask the court to look at that, it's in Appendix 2. The Lordships just have the file number. So if we go to EF 675, 675 is the front, is the exhibit page. Go into 676. The impact assessment under the heading summary, heading what is the problem under consideration, why is government intervention necessary? And then the quotation is, the government has made clear its objective of tackling the deficit and rebalancing the welfare state. Welfare expenditure is a significant driver of public spending, and the government is committed to delivering a more sustainable welfare system, including changes to tax credits, to put the system on a more sustainable footing. The current benefit structure, adjusting automatically to family size, removes the need for families supported by benefits to consider whether they can afford to support additional children. This is not fair to families who are not eligible for state support or the taxpayer. And what are the policy objectives and intended effects? The objective of these policies are to reform tax credits and universal credit to make them fairer and more affordable, to ensure that those benefit system is fair to those who pay for it, as well as those who benefit for it, ensuring those on benefits face the same financial choices around the number of children they can afford as those supporting themselves through work. Encouraging parents to reflect carefully on their readiness to support an additional child could have a positive effect on overall family stability. The changes are part of a package which will deliver a more sustainable welfare system and return expenditure on tax credits to 2007-8 levels in real terms. So once again, within that box, we have the reference to the same financial choices around the number of children. Those on benefits face the same financial choices. And then we have its intended effect on the approach of parents, encouraging parents to reflect carefully on their readiness to support an additional child, but has a positive effect on overall family stability. And then it says 3 options were considered. And I don't think the detail of that matters. The reference to whether the measure should apply as flow measures means is the description of a situation in which you ensure that the children who are already qualifying for child tax credit, however many of them there are in the family qualifying, have a cut-off date, you preserve the position as it was before. So the answer in the rest of the box is do nothing is not sustainable. Options 2 are the preferred options, as the insurer's family would not have cash losses from the policy at the point of change. That relates to the submissions I've already been making about being necessary to look at the policy as it develops fully over time. And then that, in essence, is what I need from the impact assessment, the source of the materials quoted by Lord Justice Leggett. There is a reference to the main affected groups in the box towards the top of page 677. The main affected groups will be those currently receiving tax credits or universal credit. That's all fairly obvious. I don't think I need to spend more time on that. So that's the policy background that's referred to in the witness statement. Lordship will have picked up the fact that neither in the statutory scheme nor in that policy material is there any reference to any form of mitigation measures. Those of your lordships who were involved in the benefit cap and bedroom tax litigation will be aware that a great deal of the discussion about justification turned on the ability of discretionary housing payments to deal with individual hard cases. And so that structural flaws, as people like me were arguing for, could be dealt with by the discretionary housing authorities to deal with the matter through DHPs. There is no such mitigation system here at all. We simply have the sharp effect of the impact on children as the policy rolls out. Now, finally, on the factual material, your lordships and my lady will have a short description of the position of the individual claimants at EF 205 and 206, so pretty well where we were just before. I won't read it, but their circumstances are spelled out in paragraph 13 and 14 of the judgment. The material that is summarised by Lord Justice Leggett in relation to SC, the court will find, I'm not asking the court to look at it now, we maybe need to, possibly as the argument develops, but the court will find that material in a witness statement of SC at EF 550. And similarly, the court will find the material supporting that and giving further important detail about her personal circumstances at EF 561. My lord, my lady, can I then summarise? I hope this is appropriate, possible to do this before the short adjournment, the position that we've got to as a result of this examination of the statutory scheme and the policy material, and do so in 6 points. 1, policy creates what we have described in the case as a cliff edge, in our printed case I mean by that. Assuming the members of a household remain constant, the birth of a child after April 2017 means that the household has a reduced financial income for the duration of the child's qualifying income by virtue of age, as long as they remain on child tax credit. There's more than one child, that financial effect can, as we've seen, be very large indeed. Point 2, the policy is unaccompanied by any mitigation measures such as DHPs. 3, the possibility of pregnancy or actual pregnancy confronts the adults with immediate choices about sexual behaviour and/or continuation of the pregnancy. 4th, the policy is unaccompanied by any analysis of the needs of those financially affected by it. In particular, it does not pretend to be accompanied by any assertion that the original pre-April 2017 position over-provided for members of the household, in the sense of providing for an income out of the keeping with that paid historically on benefits such as income support, job seekers allowance, or indeed child tax credit itself. 5thly, policy will affect claimants whose circumstances have deteriorated since their children were conceived. For example, a family of 4, 2 of whom were born after April 2017, will be caught by it if they become unemployed. Because there are no mitigation measures, there is no mechanism for dealing with this. We say, in brackets as it were, that the present pandemic provides a vivid illustration of the way in which families who were responsibly living well within their means at the time they founded their family can find themselves in wholly unanticipated circumstances. And sixthly, the policy's potential impact on sexual or reproductive behaviour necessarily engages profound religious and moral beliefs. Well, those are my 6 points. At the time, I mean, it seems a fairly short set of submissions so far, but if that will be a convenient moment, then it would be for me.
Yes, certainly. We'll adjourn now and resume at 2 o'clock.